All right, we are live once again. Tonight we have part 2 of the Just Ask Seth series. So we're going to go through 3 or 4 more questions with Seth. So we're going to count this down, and then when we get started, Seth will be in here to answer our questions. Well, good evening, Seth.
Good evening. Thanks for having me on, Mark.
Yeah, good to see you again. How's your week been since we last saw each other?
It's been busy. It's been good.
No complaints, huh?
No complaints.
It doesn't help. All right. Well, let's kick this off. Here's episode 2. Last one we went through and had some questions that you got to kindly answer for everyone. So let's go through this next round of questions, and let's get started with: do you do Miller's Trust and QIT Trust? Matter of fact, let's say, what is a Miller's Trust and a QIT Trust before I go on to the rest of the
A
questions?
Miller Trust and a qualified income trust are the same thing, and they're designed when a spouse has, or if you're single and your income is over the Medicaid minimum, or if you're in a couple and your income is over the Medicaid minimum.
Okay.
So it gets pretty complicated. So I'd assume that if you're over the minimum for income for Medicaid, you're going to be able to qualify for Medicaid. That's not the issue. You can always give up the excess income. The challenge is qualifying based on assets and keeping as much income as possible. So there's a minimum for one spouse if you're married, and if the other spouse is under a certain amount, you can transfer income from one spouse to another.
Okay. And help my naivety here with, regardless of if someone comes in to protect assets whatsoever, there's still a 5-year look back. Does 5 years have to pass, or is there?
If you give away assets
Okay.
then there's a 5-year look back period on gifts. Now, between spouses, there's no look back period. And when there's a couple, the rules are very different than if it's a single person trying to qualify for Medicaid.
Okay, I'm glad I asked that. So that is on gifts, right? So as far as coming in and protecting the assets, they can do that from day one as a couple, or
as a couple, the first thing that we do generally, if one person needs to qualify for Medicaid and the other does not, the qualifying person is called the aid recipient, and the couple that stays, and the person that stays not on Medicaid is called the community spouse. So transfers between spouses don't count, as they're not a problem. They don't count. So the first thing we often do is transfer assets away from the aid recipient to the other spouse, so that if one of the aid recipient spouse dies, their Medicaid estate recovery can't recover against that spouse's estate.
Okay. And so for someone that comes to you for this and they like to have one for their excess income because they need to go into a nursing home, and that's a pressing current situation, so they can still get one set up.
We can set up a Miller Trust. That's rarely the hard part.
Gotcha.
Okay. The hard part is configuring assets on a 5-year basis if you have time to do something with them, or on an emergency basis. On an emergency basis, there's things that you can do to save 50-60% of the assets. On an emergency basis, you can transfer 50-60% of the assets away that are over the limit. So for example, for a couple, it's 154,000 or so is the
Okay.
limit of countable assets. Unfortunately, if you're not a couple, the limit is 2,000.
Okay.
So it becomes, but that's the issue, is getting the assets under, and then maximizing income for the community spouse. And then the money that's forfeited would go through a Miller Trust.
Okay.
And it's just a technical tool to qualify. It's
Okay.
not the hard part.
And it really obviously gets complex, right, Seth? So that gets into where, what are the assets? Is there a home? Is it cash? Is it, land, vehicles? So that gets pretty much off in the weeds, and you have to really see the overall picture and then know which direction you can go. I'm assuming is correct.
Absolutely. Medicaid is complicated. It's not intuitive. Certain things count, certain things don't. House doesn't count. It doesn't count for as long as the equity in it's less than 713.
713. Okay. All right. All right.
So it's complicated. What we do is we sit down with clients and we go through all of their assets and all of their income and put together a plan.
Very good. All right. Next, my grandparents passed with no will. Ever since I was a child, I lived on the farm and was supposed to own the land when they passed. The whole family knows this. Now the heirs want to be bought out.
All right. So we get this a lot. If there is no will, then it is unlikely that there's a solid argument for the person who lived on the property to recover the entire property.
Okay.
So what does that mean? That means I would probably recommend that this person attempt to become the administrator of the estate and work with their siblings if they want to stay a farmer.
Okay. And this just sort of came to mind. Let's say that there's a decent sized family. Say there's, 5 siblings, and, 3 of the other one wants to be bought out. If that other one came and said, no, they're right, they did say they wanted to leave it to them, does that have any weight? Does that help the case?
Well, absolutely. What we would do is we wouldn't file a disclaimer in, because that would just take that one person out and split the remainder up between the.
Oh, wow. Okay.
What we would do is, if I've had this issue, so what we do is we would actually deed the property out to that person, and
Okay.
they would deed it back. And
Jeez.
then we just need to consider, we'd have less to consider. The buyout would be smaller. Now, if you're the administrator, you get 5% for doing the job, and you can deduct any reasonable expenses from the estate. So essentially, you could deduct that from the amount that you have to pay the other heirs.
Mm.
So it's best to work on these things collaboratively. If it is entirely adverse, what the probate court is going to do is likely put the county administrator in charge and liquidate the property and write everyone a check. That tracks the law the closest, and that will get a case over before you and I retire.
Gotcha.
So,
well, hey, here's a layman's tip on the Just Ask Seth show. My advice is call Seth, call his office, and let's get those wills done. Let's get those power of attorneys in place, and let's not wait until after the fact. That would resolve a lot, wouldn't it?
It would. We do a lot of estate litigation as well. So we probate wills, and we do plenty of wills. But what I would recommend for any substantial asset is at least a revocable trust to avoid probate, which is easily hung up with litigation.
Okay.
I refer to revocable trusts as litigation resistant, and whereas probate is vulnerable to being hijacked by any objection, no matter how frivolous.
Wow. Okay.
For a trust, the trustee's in charge the first day after parents go or grantors go, and If someone files a lawsuit, it doesn't upset the trust unless that lawsuit has validity. So it generally discourages lawsuits. Whereas if you file an objection to a probate proceeding, you prevent anyone from being appointed, and the suit has considerable nuisance value.
Okay.
So they get filed. So again, if you would like to avoid litigation, especially in complex families, I would recommend at least a revocable trust.
Okay. Speaking of trust, my spouse died. Do I need to make changes to our joint trust? And would that, sorry, let me add on. And would that change if it was a joint irrevocable or just a joint trust? Does that mix in there?
So if it's a couple layers to this, but to the extent that the trust is not funded, it doesn't matter, because if you haven't put the asset in the trust, even if it's an irrevocable trust, you have the opportunity to divert the asset around the trust or to a new trust. So if it's not funded, it doesn't matter. And so, well, back to the question. I'll pop that thing up again, please. So if your spouse dies and your trust is good, you don't need to do anything.
Because it automatically tells it what to do. The trust directs it.
Well, let's assume it's a revocable trust, it's still revocable when one spouse dies. Okay. So let's say there's a house in this trust. The house is still in the trust, and the surviving spouse is the trustee for this trust. So at any time, the surviving spouse could transfer the house to himself or herself.
Yeah.
So the spouse could leave the asset in the trust, and when that spouse departs, the next trustee would take over. And so you've essentially avoided 2 layers of probate.
Okay.
And so that is a distinct advantage of a revocable trust.
Okay. All right. This next question, I'm going to pop up 2 different screens because it was too long for one. So I'll do this first one and move on to the second half of the question. My sister Kim passed away in 2006, leaving behind a husband, Jim, and a daughter, Tracy. My widowed mother, Bernice, passed away in 2024. She didn't have a will. I'd like to know if my niece, Tracy, and Jim will inherit from my mother's estate, since my sister Kim predeceased our mother, Bernice. I don't think she should, because Jim and Tracy have not been a part of since Kim passed. Wow.
Okay. I'm not sure if I remember the whole question, but I'll start by tearing off the end. Oh, put it back.
Here's the first.
The second one part. So let's go ahead. This is just really a variation of a question we've already had. I don't think that she should, because Jim and Tracy have not been part of the family since Kim passed, is what they mean.
All right.
Doesn't matter if there's no will, then it doesn't matter if somebody's been estranged. State law dictates, and you'll inherit from your parents' estate. So the normal inheritance is, if you're married and have children, then a third of the estate goes to spouse, and 2/3 of the estate is split by children, so long as there's 2 or more children. If there's only one child and a spouse, then it's 50-50. So everybody in this scenario inherits. They inherit under intestate law. No matter how bad they've been, how long it's been since they visited mother, no matter whether they took care of mother or not. The law says if you don't like that outcome, do an estate plan.
Okay. All right. Next is our final question of the evening, and hope my southern tongue does not get in the way. You can correct me, Seth, if it does. I like to do a codicil to my last will. Codicil to my last will. Why are you telling me that you don't do those?
Okay, so we don't do codicils as a rule. And the reason don't do a codicil is we believe that a codicil is something that comes from a time when people drafted documents with a typewriter, or God
Okay.
forbid, a quill and ink.
Okay.
So in a modern world, there is no reason to be doing amendments and codicils to wills. They cause problems. We litigate these things. So what if the codicil is missing? What if the will is missing? The original will is missing. What if there's logic problems in the connection? I would always want to just start over with a new document that is coherent entirely, than try to tack changes onto an old document. Now,
Right.
once we've done a document for a client, here's how we handle some of this stuff. So if a client needs changes to their estate plan within a year, we just assume it's because we didn't ask the right questions, and we'll make changes at no cost. The client will have some work to do. They'll have to come in and sign the documents with us.
Yeah.
But we don't charge for a year. Now, after a year, changes, we generally do all of this on a flat fee. But after a year, we would just charge for paralegal time, which would be a fraction of a flat fee, to update beneficiaries, or you want somebody else to be the trustee. Well, we're going to make those changes, and we're going to completely replace your will, and we're going to completely with a trust, it's called restating the trust. The cool thing about a trust is if you have things in the trust, you can restate the trust and they stay in the trust even though you completely changed the trust. So it's modular. Okay. So long story short, codicils and amendments cause problems that are not worth. It's not worth incurring this kind of liability, and we avoid doing codicils. We'll do it again, and if you need changes, we'll do them for a fraction of the costs that we would a new will or a new trust for.
Yeah, Kim said that's good to hear. Seth, let me ask you this, and this is probably going to be mentioned throughout this series as we continue to do other shows. And I think I'm coming from the space of obviously being in the senior industry. This doesn't apply just to old people, but with that said, with your profession and the things that you see, the circumstances you see, the stories, the family conflicts, etc., what would you say to people? Like what are the main things that they should reach out and call your office to just get started, and at what age is a good to do that?
Well, we see estates of people in their 20s and 30s. It's probably always a good time to have an estate plan. We see estate, and somebody younger is less likely to litigate, but it'd be good for them to have an estate to actually I've seen some cases litigate where a child has gone and the parents are divorced, and there were issues. So I think you should do an estate plan as soon as you have the bandwidth to do an estate plan. Later in life, complex families and significant assets and businesses, those things need to be addressed proactively with an estate plan, or the results are often catastrophic.
Yeah. I tell you, especially as far as getting older, it's a lot. I mean, I'm watching what my parents are dealing with, having things set up, and even having things set up, there's enough stresses that comes along with that, trying to, get things in place. I mean, it gets pretty complicated, to say the least. And just want to encourage people to reach out, just to call your office and ask questions, and I will get charged to ask questions. You don't know until you ask, right? So is there anything you would like to add before we go?
Old age is not for sissies.
No, it's not. It is definitely not. So, all right. Well, with that said, Seth, thanks for coming on here and doing the episode 2 of Just Ask Seth. And we will be putting together another episode with some fresh new questions. So, if anybody has any questions they want answered, you can send that in, make a comment on the YouTube video for questions you would like to have Seth answer on Just Ask Seth. So, with that said, I'm Mark Little. And until the next show, we will catch you later.